Thank you, counsel. I'll call forward the attorneys on 124-972 State of Kansas versus Richard Allen Goens.
Good morning, may it please the court. I'm Ryan Enninger, Assistant Appellate Defender. I'm here on behalf of Mr. Allen Goens this morning, defendant appellant in the present case. With the court's permission, I'd like to request 3 minutes for rebuttal.
3 minutes is granted.
Thank you, Your Honor. A Riley County jury convicted Mr. Goens of felony murder, attempted aggravated robbery, criminal discharge of a firearm, aggravated battery, aggravated assault, and possession of marijuana with intent to distribute. Trial court sentenced Mr. Goens to a hard 25 and also a consecutive term of an additional 142 months imprisonment. Unless I'm directed otherwise, I'd like to spend my time focusing on the first issue raised in our brief this morning. And I would submit the second remaining issue on the brief. Today, I'm asking the court to order a new trial on behalf of Mr. Goens due to the fact that the district court failed to instruct the jury consistent with the cautionary instruction regarding the testimony of accomplice witnesses. This is instruction from PIC 4th edition 5109. It instructs the jury to pay particular caution to the testimony of an accomplice witness, of which there were 3 in this particular case, I guess 3 accomplices, but there were only 2 that provided testimony at trial. The cautionary instruction was not requested below, so I must argue that this instructional error constituted clear error, requiring reversal of his trial.
Other than the imprimatur of the court giving the jury, what else would tip the balance to get past clear error burden on this one? Focusing on the defense counsel's closing argument, where it was made clear that, you know, this testimony was coming from accomplices, that they had deals. I can't see anything else that could have been said in closing arguments that, you know, brought that matter in front of the jury any more clearly than what defense counsel did. So really the only thing you got is, you know, the judge reading from PIC instruction. So how does that doesn't even tip a balance? I mean, you've got more than to tip a balance. You've got to go further. So how do you get there?
I suppose my response to that, Justice Files, would be twofold. One is, of course, the attorney's arguments aren't evidence. So
PIC instruction.
Right, and that PIC instruction specifically identifies and tells the jury beyond just my arguments, just beyond counsel's argument, that the counsel can argue about the evidence, but that specifically directs the jury to that evidence need to be viewed in this particular manner. And I understand that argument was made, and those were brought to the attention of the jury. But there's also been the other part of that is this court has consistently held that where there's a lack of corroboration and the extent and the importance of the accomplice testimony is acute here. And in this case, the state's entire pretty much case was built on the testimony of accomplice witnesses. So in those instances, I would argue that does become critical. It does become a situation of clear error if it's not provided to the jury. Because in this case, we had a lack of corroboration. We had a lot of sort of differences everywhere in everybody's, especially in the details of the accomplice's testimony. For instance, one thing that I think I pointed out that I found should carry some significant weight here is both of these accomplices frequently discussed Mr. Goens and his firearm. One witness said, one accomplice said, well, he had a black and silver firearm. The other witness said it was camouflage. That's a very big difference. And in both cases, you know, they said, I saw him with the weapon. Mr. Sutton, who drove Mr. Goens home from the incident, claimed to watch him disassemble his firearm and throw it out the window. At that point, you'd think he would have a pretty good view of what that was. Mr. Hitzman, Jalen, said that firearm was pointed directly right at him. he also, I think, should have had a pretty good idea of what that firearm looked like. And there's a distinct difference between those two testimonies. One's a camouflage, one's is black and silver. Other things, the
Counsel,
witnesses.
just, I'm sorry to
No,
interrupt you. Was a general credibility instruction given?
it was.
Okay, so you're pinning this on that there wasn't an instruction about credibility of accomplice testimony, but a general witness credibility. Okay.
Right, a general witness credibility instruction was provided to the jury.
And why didn't that suffice?
Well, I think it didn't suffice because in this case, we have so many different differences between the accomplice's testimony.
Right, but they're all witnesses.
Right, I'm sorry, I don't understand. They're all witnesses, but
But the
Yeah.
jury was instructed, if, a witness, it's up to you to decide the credibility of witnesses. And so even though they're accomplices, they're still witnesses, right?
correct.
So why, I don't understand why that didn't.
Well, I mean, basically what I'm arguing is based on this court's precedent, what I've seen is, in what's out there is if there's a number of issues and lack of corroboration between the accomplice witnesses, this court has consistently said that that instruction should then be provided.
Right, so it should then be provided, or that it's legally appropriate and it's factually appropriate, and then as Justice Biles said, we get to whether or not a different outcome
Right.
would occur, and given that they were instructed on the credibility of witnesses, what's so you're saying that including the word accomplice in there would have made a difference in the outcome of trial, right?
That's, yeah, under the clear air standard, I have to argue that if that instruction had been provided, the outcome would have likely been different in this case. And that argument is that due to the number of sort of differences in everyone's testimony, that should have been even brought forward even more for the jury to appreciate that counsel's arguments, the general credibility and being told is not enough, because it has to be specific. The instruction's there for a reason. It should be provided to alert the jury to that fact.
Along those lines, one of our cases, the Moore case, when talking about this issue, described it this way. Or described the question we should ask this way. And that is it possible that any of these jurors who heard this testimony didn't realize that these witnesses' credibility as accomplices was at stake? From your perspective, do you think any of these jurors did not realize that these witnesses' credibility was at stake?
No, I think they absolutely would have recognized that their
Right.
credibility is at stake, but that instruction then says, make sure you weigh.
I understand that,
heavily.
but our precedent says that that's one of the ways that we can answer this question.
Correct, and I agree with that. But as I said, in a case where you have all these different accounts from different witnesses.
But
The
you
court has
concede
also
at
said
least that it sounds to me like you're conceding that the jurors in this case were well aware that the credibility of these accomplice witnesses was being contested by the defendant.
Well, yeah, I mean, absolutely. I mean, that was, through the entire trial, defense counsel brought those issues out. I'm just saying that in this particular case, under the facts of this case, due to the fact that the entire state's case was built on accomplice testimony, this instruction should have been provided, and it was clear error not to do so.
Right. You mentioned the discrepancy in the testimony, but wasn't the defense essentially that whether or not there was a plan? I mean, isn't that what it really boils down to? And then how do you account then for the mother of one of the accomplices' testimony that sort of corroborates the existence of a plan? She's not an accomplice.
Right, and I understand what you're saying, just that seems to be an independent corroboration beyond just the accomplices themselves.
Right.
It's just somebody that's not an accomplice, but is also a witness and has been corroborating. The thing I'd point you out to in the record would be her testimony. I think it's around 396 to 398. where she says, when she initially explains what her son told to her, there's important detail in there that he says, she says he told him that he drove there, which is completely different. And so there's another discrepancy there, even in what she's saying. And so I think that's important too. There's a number, and I understand there's a difference between discrepancy on the details and discrepancy on a sort of general corroboration. And what I'm arguing today is that the details matter, that we can get to a general corroboration, but when you really get down to it, a lot of these details are big problems, such as the color of the gun.
And I guess I was wondering also whether the cautionary advisement that we have for accomplices should be extended to non-accomplice witnesses who are just talking about the admissions of an accomplice.
And that's
And
something.
I don't know that we've addressed that, or
Right.
if how you would view that sort of argument.
I think that supports my argument as far as all the evidence in this case came in one manner or another through an accomplice. Now,
Well, didn't Goens admit to bringing the gun, for example?
he admitted to bringing a gun, and he admitted to the.
So why does the
the
color
marijuana.
of the gun matter? I mean,
Because
why
it's
would
a discrepancy.
why would the discrepancy of the color create a real possibility that the jury would have returned a different verdict when Goens has already admitted that he brought the gun?
I just think it's an important discrepancy in the fact everybody's recollection of this event and the fact that, yes, I had a weapon,
But
but
the discrepancy has to lead us to be firmly convinced that had the instruction been given, it creates a real possibility the jury would return a different verdict. And you've focused on this color discrepancy. And I guess I'm just asking, how does that, why would that matter in a juror's mind, even if they were inclined, perhaps?
well, I think it matters because there's some indication here, as Mr. Goens testified, that, hey, I actually gave them money to buy this marijuana. I became concerned that I was actually the one that I was going to get ripped off. So I then approached to say, hey, what's going on here? So I think it's important that if these two accomplices have a credible accusation against my client, then they ought to remember some details about like the nature of the weapon. Is my argument on that those details would then matter. And if they just sort of ad hoc came up with these things, then their ideas, their testimony regarding the details would likely be different. It's easier for us to come up with a general sort of corroboration of this was our plan, but then things start to fall apart. As I know this court's seen through various investigations, interrogations of defendants, during things start to fall apart when you start to get to the details. See, I'm out of time. If the court, unless the court has additional questions. Thank you.
May it please the court, David Loudon, Deputy Riley County Attorney, appearing on behalf of the state of Kansas. Like Mr. Ettinger, I will submit the second issue on the brief, unless this court has any questions. As with regard to the first issue, it should be clear that the defendant did admit to having the gun, bringing the gun, firing the gun, whether he did that on purpose or intentionally. That remained, that's something that was an issue, but it was a felony murder case. So there was a death in the context of an attempted robbery or a robbery. What we had, the central issue in the case was he there to buy marijuana or was he there to rob Mr. Zomaznik? They would submit that basically what's happening here in this appeal, the argument is the jury should have paid attention to this other stuff and should have come out with a different result. So we're going to complain that this accomplice witness instruction would have been the turning point for this jury. The state would submit that that is patently wrong. This court must be firmly convinced that had this instruction been given, that the outcome of this trial would have been different.
Did the other witnesses make any deals with this?
Only the two co-defendants who testified, Shamar Sutton and Jalen Hitzman.
That Was that explored on cross-examination?
Yes, that was explored on cross-examination. They discussed, in fact, that they got reduced sentences and reduced charges in exchange for their testimony. It was a central part of the argument. As Justice Stiegel has pointed out, I mean, some of this stuff had come out. How does this change things? I don't know that it changes anything. This court has indicated that an accomplice instruction is not a mandatory thing. It does not have to be given. This court has indicated some cases that there is no error, let alone clear error, when the general credibility instruction is given on testimonial evidence. I would submit that there has been no error here, let alone clear error. This court can't ignore that in the past, it has said juries can be trusted to figure out that when testimony and the credibility of that testimony is an issue. Jurors are not stupid. They can figure this stuff out. We would submit that everything that happened in this case gave them the roadmap to make a decision that was in line with Kansas law. I personally don't understand why we even have an accomplice instruction. Given this general credibility instruction, it's unduly focusing on one part of the case, I believe, and we try to shy away from doing that. Nonetheless, I'm not here to overturn history when we have, case law saying that this is somehow important. But I think the recognition that this court has had regarding the general credibility instruction and that it's not a necessity somewhat undermines the notion that it's this all important thing that the defense wants to bring forward today. I will say, if we are going to look into some of those things that the court has in the past said, let's look at how important was this testimony, this accomplice or co-defendant testimony. How important was it in the case? It was very important. We'll concede that. We disagree with the defense. There was corroborating evidence. Dawn Hitzman, Jalen and Dylan Hitzman's mother.
And I'm going to interrupt you there. Just for clarification, did the accomplice testimony go only to the contested question of whether there was a plan to rob, or did it also go to the elements of criminal discharge?
I think the focus was on
The focus was on plan to rob, as far as I can tell.
and the felony murder. That certainly was the
Well,
central
but
issue.
wasn't the felony murder predicated on criminal discharge as well? Or am I reading that wrong?
I think it was based on the
The ag robbery
the
only?
robbery. Yeah, I could be wrong and I don't want to misstate the record, but I that's my memory of it. So what we have is a situation where Courtney Yao, who is not a co-defendant, accomplice, she was an innocent person in that car. Well, when I say innocent, maybe she was part of the drug deal, but she was in that car and she said, look, they came to the car, Dylan and Jalen came into the car. They were acting cagey and just very suspicious. They never showed any money. They wanted to see the drugs before they gave any money. So they never saw any money. And then the defendant comes up and he's knocking on the window and he has brandished his firearm. And in the course of that, he demands the drugs. His testimony is, I went up there and I thought, what's going on here? And so I do brandish my gun and I do say, where's the money or where's the drugs? I don't want to get ripped off. He never asked for his money. Curious. There is corroboration, the fact that he did the robbery. So this isn't something that's standing alone on an island with a co-defendant accomplice testimony. Courtney Yao, who was injured in this case, and she was a victim of an aggravated battery. He was there to corroborate, along with Dawn Hitzman's testimony. And one could argue, okay, she's only parroting what Jalen Hitzman has told her.
Can I follow up on my earlier question? Because I just looked at the jury instructions and it appears to me that in jury instruction 4, which is the felony murder instruction, that the predicate or the underlying felonies are listed as aggravated robbery and or criminal discharge of a firearm. And the
Am I-
jury came back with a guilty verdict on both.
My apologies, Judge.
And so if that's true, does any of this even, I mean, does any of this discussion about the accomplice testimony really matter? What I'm driving at is, let's say hypothetically, we were firmly convinced that had this instruction been given, the jury might have disbelieved the accomplice testimony on the robbery. Does that well, I guess my question is, would that have changed the outcome when we have a guilty verdict on the criminal discharge?
I don't think so, no.
Does that question make
Yes,
sense? Are you tracking?
yes, I am. I think so, yes. Because if the whole focus is on whether he was there to rob or not rob, still doesn't take away from the fact there's a criminal discharge in the case, is what I'm taking you to mean.
Yeah, I wanted you to comment on whether you thought that was
Yeah,
made sense or not.
it does make sense, yes.
But does that create an alternate means issue, the way that the jury was instructed? In other words, does the listing of multiple felonies create alternative means of committing felony murder?
I think that's an option within the means.
Well, was there a guilty verdict on it? He was charged independently with criminal discharge.
He wasn't, he was found guilty of that.
Okay.
Yes,
He was charged separately.
he was
Criminal
charged
discharge.
separately, yes. So with that, the state would ask, based on the briefs and the arguments today, that this court uphold the conviction, deny relief on issue number 1, and I will submit issue number 2 on the brief and ask that this court affirm the sentence given in this case. Thank you.
May it please the court.
Can I jump in and ask you to address that subject we were just discussing? Do you think the accomplice testimony was relevant to the criminal discharge guilty verdict?
I was concerned that I'd have to say yes. I think in this situation meant that jury could have believed that the accomplice testimony was unreliable and untrue, incredible.
How does that
So-
undermine the evidence of criminal discharge?
Well, I
Let's
think,
just say that you're right, that
Well,
the
I think-
jury would have disbelieved the accomplice testimony. Can you
Well, then
be
I think-
specific as to how that undermines the criminal discharge?
then I think we might end up with a completely different jury verdict would be the only way.
But I'm just asking you to articulate how their testimony, how the accomplice testimony supported. In other words, again, if the jury had disbelieved the accomplices because they were given this instruction and they thought to themselves, it's obvious they're lying because they got deals. How would that have impacted the evidence about the criminal discharge?
I guess my response would be that there would have to be the jury would then maybe have to acquit on criminal discharge based on the test, not accepting the testimony of the accomplices. But there's no one response.
So are you saying that somebody shot at the vehicle, but not the defendant?
That would be the only possible outcome. Or is a situation, I know the facts were as they were driving away. My client there was a lot of testimony that they were all falling out of the vehicle. Okay. Jalen said that he was tumbling out of the vehicle with Mr. Goens, and that's when the gunshot went off. So there's some evidence there, I think, that the jury could rely on, Your Honor, to say that my client wasn't actually responsible for the discharge of the weapon, if you understand what I'm saying. If you look at the record, Jalen said, he opened the door. There's a big difference actually in what everybody says about what happened in that car. I know the state brought up Courtney's testimony, and Courtney's testimony was that as soon as my client appeared, brandished his weapon, Jalen and Dylan hopped out of the vehicle. And Jalen says, and then she goes on to say, my client chambered around, she could hear him chamber around, pointed the weapon at the Tanner's back. behind the seat. At that point, she said he demanded the marijuana, and that was Courtney's version of events. Jalen said that he came up, brandished the weapon, pointed at him. He told Tanner, go, 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 drive away. As Tanner pulled away, he claimed that he was jumping out of the vehicle, tumbled to the ground sort of with my client and with Mr. Goens. And I would have to argue that that would be the window in which the jury could say, well, at that point, perhaps Jalen was actually the one that caused the firearm to discharge.
I thought your Goens admitted to firing the gun.
I don't think he admitted to firing it. I don't want to misstate the record. I'd have to check that again, Your Honor, but I don't think, I think he admitted to bringing it, but I don't think he may have said that as he fell to the ground with Jalen, is sort of my recollection that the firearm went off.
Yeah, he said it was an accident, but
Exactly.
he didn't try to say someone else.
Well, I think there's some implication there that it was potentially caused by Jalen tumbling on top of him. So I think there is some room there for the jury to acquit on that. If there has additional questions for me, I yield the remainder of my time. Thank you, Your Honor.
Thank you. Thank you to both counsel in this matter. The court will take this matter under advisement.